Welcome to today's program titled Desperately Seeking Post-COVID Sales. Don't forget about the TCPA and the CAN-SPAM Act when designing your marketing communication strategy. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the text box on your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down. It will not be reread, and it is required for the CLE credit. Copies of this webinar recording and material will be distributed to the attendees in the days following the webinar. At this time, I would like to turn it over to Jordan Vick. You may begin.
Thank you, and thanks everyone for joining today. We welcome you. I'm Jordan Vick, a partner in Seyfarth Shaw's Chicago office in the litigation department, and I'm joined today here for this webinar with my partner Bart Lazar, who's also in Chicago, as well as Robert Milligan, who is in California. We know that many businesses and companies are interested in re-engaging with their customers after having gone through this prolonged period of sheltering in place and depressed economic activity. And so in order to re-engage and reconnect with customers, often that involves reaching out via cell phone, text message, email, and so we thought it would be a good opportunity and helpful for all of you if today we did a bit of a refresher on the rules that often apply to those types of communications. And so hence we are doing our TCPA and CAN-SPAM refresher. So today we're going to cover an agenda that's relatively straightforward. We'll do a brief introduction about what these statutes are and why you should care, and what they have in common. We'll cover the CAN-SPAM Act, which regulates emails in detail, and Bart will handle that. And then Robert and I will cover the TCPA, an overview of what it is, its restrictions, some of the terms of art that are used in the TCPA, and then we'll move on to recent rulings, such as the one that's hot off the presses in Barr versus the American Association of Political Consultants, which the Supreme Court just delivered to us a few days ago on the TCPA. And then we'll also talk about some best practices, which we hope will be helpful to you and your companies moving forward. What is the Telephone Consumer Protection Act? It was enacted now in many years ago in 1991. The FCC has the ability to promulgate rules under that act. It was enacted to protect privacy interests, but back then the interests that Congress was interested in protecting were a bit different because the technology was so different. So faxes were obviously still very popular. Rather than coming to your computer, they came out in paper and wasted paper, ink, and time, tied up your phone lines. So Congress was very interested in regulating faxes. Cell phone plans and cell phones were relatively new. They weren't as widely used, and also it was a charge, usually a charge per call. So Congress enacted very strict restrictions when it comes to cell phones because they were concerned about the charges that would be imposed. And now obviously we're usually on flat fees and everyone uses their cell phone and often only has a cell phone. And those all of these observations, interestingly, were recently touched on by Justice Gorsuch in his dissent in the American Association of Political Consultants case, which we'll touch on a bit later. So the TCPA places restrictions on calls and text messages to cellular phones. Those are its most onerous restrictions. It also places restrictions on calls to residential telephone landlines. Those are slightly less onerous. And then it also regulates faxes. And the monetary exposure with respect to the TCPA can be devastating because it is a $500 per call or text statutory violation that's essentially mandated if a violation is proven, and that can be trebled and increased to $1,500 per call or text if the violation is willful. And there is no cap or aggregate limit on damages. So as we'll see, TCPA is very popular amongst plaintiffs' attorneys, and plaintiffs' attorneys bringing cases as class actions because the potential for statutory damages and hence attorney's fees are very, very large. And so some people refer to the TCPA as a strict liability statute. It's a bit of a misnomer, but not too far from the truth, because if you violate it, you can get the statutory damages, and it doesn't necessarily have to be negligent or willful. You just need that to get treble damages. I'll turn it over to Bart to give a little overview of the CAN spam.
Thanks, Jordan, and thank you everyone for attending today. The CAN Spam Act was enacted in 2003 and was designed to try to stop all the spam and unsolicited commercial email that we receive. And as you can probably tell from your own email boxes and your own spam filters, it's been a mixed bag at best. So it's designed to protect consumers from unsolicited commercial emails. And although it's administered by the Federal Trade Commission, the FTC, and the most recent development was in February of 2019, the FTC was asked to reevaluate the CAN Spam Act to see if it should be changed, and the decision was not to change it. So right now we're still living in the same world, and the CAN Spam Act is not as, in some ways, it's not as big a concern in terms of individual plaintiff lawsuits, but it's really important, certainly in terms of the goodwill that you have with your recipients of the communications and how you frame communications to your customers and potential customers. So there's requirements regarding having the sender and header information that's on all emails so that we know that the communication comes from a particular source and can be traced. And then there's some gauging over what the content of commercial emails can be, and we'll talk about the differences between what a commercial email is and a transactional email is. There's a requirement for an opt-out mechanism, and there is, which can, if you do have an opt-in, we'll talk about how that can be, you don't always have to have that opt-out mechanism. But there are some substantial penalties that can apply. The Federal Trade Commission can obtain $16,000 in terms of fines for every violation. And the Federal Trade Commission and the state's Attorney General have enforcement availability. There is no private right of action. There is an action for what are called internet access providers, but that's a rarely pursued claim. And so it's not a plaintiff's class action case, although sometimes plaintiffs will try to take a commercial email and try to weave in an unfair and deceptive trade practice claim. And as you may be aware, effective January 1st of this year, and then and now enforcement effective July 1st of this year, is the CCPA, the California Consumer Privacy Act. And that may be the kind of statute where a consumer who has the right to instruct a business not to sell personal information, that could be the kind of claim that could come out in terms of commercial emails. But that's a lot of acronyms to provide. So the question is really, what do we really care about these acronyms?
Yeah, so it's always an alphabet soup when we're dealing with TCPA, CAN spam, FDCPA. There's a whole range, and the reason is not so different for these particular statutes we're talking about today. It's because you want to avoid exposure for your company, and particularly with respect to the TCPA, because of the hefty damages provisions and the potential for class action lawsuits and the very active plaintiffs bar that's involved in the TCPA. You have to care and you have to know, at least basically at a high level when you're doing marketing, when you're reaching out to customers, and even when you're, if you are in a campaign and you're reaching out to potential voters, you have to be mindful of these regulations. As Bart also mentioned, there's a potential for enforcement investigations or actions, particularly in the TCPA space. The FCC, I think, is been indicating, especially with COVID, about getting a little bit more aggressive about trying to enforce the statute with respect to people who are, marketing, misleading marketing with respect to COVID and health, and doing things which, are really harmful to consumers or trying to hide their identity. And obviously that's something that there is support for among, the general population. And so I think they're trying to get a bit more active in that sphere. So I wouldn't be surprised if we see more enforcement, investigation, and actions in the TCPA space coming up. In addition, and most importantly, it's customer goodwill, right? You don't want to annoy your customers. You want them to know that you respect their privacy, but at the same time, you need to provide them valuable information and valuable services, and valuable discounts and special deals. So it is a balancing act, and that's why we thought it would be good to go over kind of this alphabet soup with you today. So we talked about some of the differences, and I'll turn it over to Robert to speak to what these statutes have in common.
Thanks, Jordan. And I can't think of a more timely period to be having sort of this discussion about CAN spam and the TCPA. You have a seminal Supreme Court decision that just was rendered. You have some FCC decisions that were just rendered, and we're in the middle of a pandemic. So although most of us would normally be in the middle of vacations now, a lot of us are at home working for our companies, trying to protect our companies and our businesses. And so, what we've seen with this statute and some of the case law interpreting it is very significant, and I think that a lot of companies at this point are kind of in survival mode, and so they naturally look at their customer base and the engagement and interaction with their customer base to drive sales. And so lots of us have received, text messages from people, companies that maybe we've signed up in the past, emails from companies that we've maybe done business with in the past. But there's definitely an outreach from companies across the world, trying to engage with their customers, and that is fine and that is good. I think the trick is, and what you're seeing with this explosion of TCPA lawsuits, is that a lot of companies are maybe cutting corners, may not necessarily have in place compliance mechanisms. And one thing that we see often is there's this outsourcing function where they're relying upon a third-party vendor, and they think that somehow insulates them from TCPA liability and exposure. But oftentimes that's not the case. And even when they do it correctly and maybe have an indemnity provision with that marketing provider, there can still be exposure, and it's not a sort of get out of the lawsuit free notion, and so that's why there's a lot of attention on these particular issues at this point, because the business side of companies are really trying to generate sales, and they may be taking chances, and there may be a lot of unstated assumptions that are not necessarily correct, as far as that their CRM database, their customer contacts are all free and clear for a mass marketing campaign. And there's a lot of issues with that, because as you can see with this regulatory overlay, there's a lot of boxes that need to be checked before you should be engaging in these communications with customers. I'm based out of California, and California is one of the more attractive forums for the plaintiffs' counsel. The courts out here don't necessarily have a hard time certifying classes. You can typically, get a class certification motion in front of the court in a relatively swift manner, and the courts are not afraid of issuing large awards, and also issuing large attorney fee awards as well. So it's become somewhat of a popular forum. That being said, there's also a lot of technology companies that are based in California. A lot of the significant plaintiffs' attorneys are based here as well. So we've seen a lot of action during the pandemic. Lots of filings, as Jordan mentioned, that we expect with election season occurring. Now, whether a lot of those suits are going to be viable or not is a good question. But certainly in the past, we've seen during the elections, and even now, we've seen a lot of TCPA suits brought. The notion that you just buy the voter list and then sort of text away, that can only get you in trouble. We've also seen a lot of TCPA lawsuits in the cannabis space, particularly on the text messages. You're seeing different factual scenarios. A scenario where there's the texting of non-clients who have never signed up or consented due to the company's mass texting policies or practices. You've seen instances where there's suits with respect to texting non-clients who never signed up or consented due to third-party inputting error. Also seen instances where there's text message suits being brought by consumers who did not give adequate consent to being texted. We've also seen some cases being brought against nonprofits. There's been a tremendous amount of telemarketing going on during the pandemic as well. I'm looking at my phone now, and within the last month, I've received over 40 telemarketing calls. I have to get around to deleting those. But I think you would probably agree that we've seen a tremendous amount of input or uptick in the number of telemarketing calls, and that's obviously governed by the TCP as well. Some of the key issues that come up in the TCPA suits, whether it's the direct marketing call, whether it's the text message, whether it's facsimiles. Is whether or not there was consent, and the best practice typically being do you have evidence of written consent, and then depending upon the requirement, for instance, in the example of facsimiles, the requirement for facsimile advertisements that you have a opt-out notice, and so. And also in the text message context, the requirement of having the ability to opt out and having that baked into your automated process. So these are some of the core issues that are involved in the TCPA statute. We're going to get into a little deeper dive, and I think the beauty of today's presentation is that we now have some Supreme Court guidance. We have some new FCC guidance, so it can, from a marketing perspective, from in-house counsel or from the marketing team's perspective, you're getting the latest, greatest sort of input on this Byzantine statute. I would encourage you all to get in your questions. This is a unique opportunity to ask questions that are maybe near and dear to your own issues and hearts. With that, I'm going to turn it over to Bart, and he's going to get into a deeper dive on the CAN-SPAM Act.
Thanks, Robert. And I would like to amplify what Robert said about the service provider space. Certainly in terms of sending out emails, acquiring email lists, there's a lot of traffic in those fields. And while Can-Spam Act may not be as enforced as TCPA and some other statutes, marketers have to consider the recipients of communications and the relationships that they're establishing, they're establishing, or trying to establish with the recipients of those communications, and treat the consumer or prospective consumer appropriately, and give the consumers the chance to exercise their choice. It's a privacy principle, but it really is one that is connected to the basis of Can-Spam and protecting against unsolicited commercial emails. So here's the basic 5 requirements. So emails have to contain an accurate header or subject line. You don't want to mask the identity of the sender to falsely create the impression that it's coming from a friend or a celebrity or from someone other than that's not the ultimate sender. There are some distinctions when you get into the in-depth of the statute regarding a sender and an initiator, and if you work with a service provider. The key really is that it should the name should go back to a legitimate business that can be tracked. Once we determine there's a commercial email, and we'll talk about that in a second, the commercial email is going to have to identify itself as an advertisement in some way, unless you have an opt-in. It has to have a valid physical address of the sender, and you need to provide an effective form of opt-out. Now here's, we talked about, Jordan talked about everyone working at home. Here's one enforcement, the most recent enforcement actually of the Can-Spam Act by the Federal Trade Commission, and it shows where a lot of things can go wrong. And the point here is this is a promotion of a work-at-home program, and definitely while the FTC will often reach out to companies and try to coerce them into compliance without formal settlements or without litigation. So the public cases end up being sort of the worst, most misuses of the statute. So these are emails that were sent to promote a work-from-home scheme. The from lines, which are blotted out to protect the innocent, but the from lines or the guilty, I guess, and are masked as coming from news organizations. The subject lines in the email were false. They were stating that that there was an endorsement going on, that the celebrity shown in the email was endorsed. So you have a news organization like a CNN being shown as an inaccurate source of information, and you have a celebrity as being that is not endorsing a program, actually endorsing the program. The company involved in this case not only promoted its work-from-home scheme and made substantial money from consumers, that they also sold the data that they received from people who enrolled in the program to third parties. And the company involved in this case had a $1.5 million settlement with the Federal Trade Commission, and some of the parties, the individual parties, were banned from engaging in these kind of affiliate marketing or other kind of marketing programs. So that gives you an idea of how the system can be misused. So how do we use it appropriately? The first thing is actually try to think about what a commercial email is or a transactional email, because so commercial emails have to have the items that we talked about in terms of the opt-out and the valid physical address, while a transactional relationship email does not have to have all of the requirements of the CAN-SPAM Act. It still should not have a false header. But when you engage in a program, you have to look at your what email you're sending and whether or not it is transactional, something that is relating to a business relationship that's established between the sender and the recipient of the communication, or something else that's commercial, trying to advertise or promote a product, and there is this a category of other that can be the charitable political type of situations. The Federal Trade Commission adopts what's called the primary purpose test to make this determination. And so these items are elements of what would be a transactional email. And if the content is part of an agreed transaction, it helps the transaction, provides information about the transaction, either at the time of or going forward. So you can have a membership newsletter, subscription communications, a regular mailing list, and you don't have to, in each situation, maintain the all the elements of the CAN-SPAM Act, and that can be, that's beneficial for the sender, that it's not as detailed. But many clients can fall into the gap of sending out what they believe to be a transactional communication when it really is a sales piece. And that's what the CAN-SPAM Act tries to avoid. And the way that when you're looking at a communication that goes out to a mailing list, how do you make that determination, or how does the Federal Trade Commission make that determination? The first thing is actually the subject line, and that's really important to look at. When I review advertising content and review email content, a lot of times the clients don't send me what the subject line. And so I'm looking at this content and I say, oh, it looks fine. It looks like an appropriate communication to your membership or to your customers. But can you send me the subject line? That's really important, because if you send the subject line that says account notice or membership information and then have sales content, well, that would be more commercial. And the reverse, you don't want to put necessarily go so far in a subject line that turns what would otherwise be a regular communication to your mailing list, a transactional communication, into what would be a sales piece. Great new offer. And then, see below, that probably would go past the slippery slope on commercial content. So once you get past the hurdle of whether or not it's transactional or commercial, and again, you can have a combination of content. Let me go back for a second. You can have a combination of content. There's nothing wrong with doing that. I think the most important point is to, once it's all said and done, you look at it carefully from the subject matter line to what's first in the content to what other content is presented. And if you want it to be a transactional email, you really need to make sure that that you're not just paying lip service to the transactional relationship you have with your customer. But if you do determine that you have a commercial email, then you do have these additional requirements. The toughest issue sometimes is to identify a commercial email as an advertisement. If you're mailing to, if you don't have opt-ins on your database, then you have to identify it some way as an advertisement. Some state laws used to require that you had to put an ADV in the subject line. That it was preempted by the Can-Spam Act, so that's not required. But between the subject line and the content, you need to make it clear to the recipient that it's a commercial communication. If you don't, if it's a commercial email under the test, and if you don't have an opt-in from that consumer, then the address of the sender and an effective opt-out. And the opt-out is, of course, is going to be important. There, once you develop, if you have developed your program, it's worthwhile to look at how you are handling your opt-outs, because the Federal Trade Commission and Can-Spam allows business line opt-outs, allows there to be menus related to opt-outs, so that a consumer or recipient would only opt out of specific types of communications. And so there are ways to structure your program so you're not always asking your recipients of commercial emails for a what would be a broad opt-out, which would prevent you from sending other communications. So now I'll pass it back to Jordan and Rob to handle the TCPA piece.
Thanks, Bart. So as Robert mentioned, there's been, a huge explosion in the TCPA, which was a relatively unknown statute back in 2010, kind of just lingered under the surface after being passed in 1991 before it became a real vehicle for litigation. And then you see it kind of reached its apex in 2016, and now we're seeing, kind of slow tapering down, although I will say, and to Robert's points about getting a lot of calls and text messages during COVID and shelter-in-place, TCPA filings for this year are up about 26% from last year. So where are all these cases getting filed? A lot of them are getting filed in California. A lot of them get filed in Illinois, in the Northern District of Illinois, where we are. Georgia, Florida, Indiana, all top filing jurisdictions. And now where you file your TCPA lawsuit makes a big difference, because there are huge circuit splits on really important issues that we'll cover, like what is the definition of an automatic telephone dialing system? Who has standing to sue? Does it just take one text message, or does it take more than that? And then personal jurisdiction. So what's the power of this court to hear this dispute, especially with respect to a bunch of putative class members who may not have received any type of call or text in the state that the plaintiff has decided to sue in. So there is kind of a circuit, either blatant circuit splits or brewing circuit splits on all those issues that affect where these cases are filed. I think a lot of people were hopeful, and I know we have a question on what's the newest in the TCPA. So a lot of people were hopeful that the American Association of Political Consultants case would eliminate or reduce the vast amount of TCPA litigation, because it was about one of the most heavily litigated parts of the TCPA, which is the cell phone call ban. But unfortunately, the Supreme Court basically severed the portion of the statute that was problematic, which had to do with calls to collect government debts owed to the government, and left the rest of the statute intact. So if anything, I think we'll see a boost, a rise. Maybe some plaintiffs' attorneys were waiting to file lawsuits, but we certainly aren't going to see this TCPA litigation going anywhere soon. In terms of liability, I mentioned before that a lot of these cases are filed as class actions, and that's where you really see the liability start to pile up. Don't get me wrong, individual plaintiff lawsuits under the TCPA can still cost quite a bit to settle, depending on the number of times you called or texted the plaintiff. But a large portion of TCPA is class action, and I handle a lot of these. And so you see that in proportion to the total number sued, it always hovers around, 40 to 50% are class actions. And it was slightly adjusted in April of this year because there were a lot of individual plaintiff filings by a few firms. And so if you take those out, you see the class actions are still a major driver of this litigation. I include this next slide not because it's anything new, but just because it's always mind-boggling, the amount of potential liability. So you have the top 5 settlements in history. I believe Caribbean Cruises and Capital One were both in the Northern District of Illinois. $76 million for the class settlement there, $75 for Capital One, and then it goes down. So you can see how this liability will add up very quickly if you get hit with a class action. So in order to avoid that and reduce exposure, what does the TCPA apply to? It applies to cell phone calls, and that includes text messages. As far as the FCC is concerned, text messages are phone calls. So certain text messaging platforms are covered, those that basically allow you to just automatically send text messages and that don't require any human intervention. And so that is actually one of the recent FCC orders that came out, which was on the person-to-person text messaging platform used a lot of times in campaigns. Hi, this is Sandra calling on, writing you on behalf of Bernie Sanders. And that is a person-to-person text messaging platform, but the person who is sending can edit the message or customize it and has to, there's some human intervention usually required to send that, although it allows a sender, someone, a campaign staffer to send a lot of text messages. The FCC just recently came out and said, we're not going to say definitively that person-to-person text messaging doesn't violate the TCPA, but we're going to reiterate that if you have human intervention involved in the process and someone needs to do something, a person needs to do something before the text hits the recipient's phone, then that is not going to qualify as an automatic telephone dialing system. So that's a helpful ruling, right, compared to what you saw happen with the Barr case, which is going to affect campaigns and elections. This was one that'll be actually helpful to campaigns in the upcoming season. So that's one of the recent FCC orders that came out. The TCPA also applies to kind of novel technologies that many marketers use, such as ringless voicemails. It doesn't definitively apply to these, but I would say that it is an issue that is being litigated in several courts. So that's direct-to-voicemail marketing. There's no circuit case law on that yet, but it is brewing, and that issue is brewing in the district courts. This TCPA applies to landlines, slightly less onerous restrictions with respect to landlines. It applies to faxes, and it also allows for vicarious liability. So although that's not something that's explicitly addressed in the statute, many courts have applied vicarious liability principles, so agency principles, to hold companies or organizations on whose behalf text messages were sent, but maybe they used a vendor or another company in between. Plaintiffs can use that to kind of trace back to the original company who was benefiting from the text messaging campaign or the calling campaign, to hold that business vicariously liable. That can also happen in certain instances for individuals, so corporate officers and directors. So to just dial in a little bit further, forgive the pun, on the cell phone calls, they are covered by the TCPA. Calls to cell phones are essentially banned and covered by the TCPA if they are made using an automated telephone dialing system that is, or an ATDS, a lot of people call it an auto dialer, or if they're made using artificial and pre-recorded voices. So you don't need both. It's either or. A lot of times there's a focus on the automatic telephone dialing system, but the way the statute is written, it is an or proposition. So either way, if you use either of those things, it can violate the statute. A call to a cell phone using either of those means doesn't violate if it's made for emergency purposes. So what's an emergency purpose? So that's another recent FCC order that came out about COVID. And the FCC sua sponte clarified that certain calls relating to COVID from hospitals, from local health officials that are related to health concerns do fall within the emergency purposes exception. But it's not broad in the sense that it doesn't apply to helpful services that consumers might want during COVID, like grocery delivery or other things. So it was a narrow clarification by the FCC with respect to COVID, and that was an order that came out in March. Before that, courts have held that one was a Kroger case where Kroger texted its customers to let them know that food was potentially contaminated, and there was a TCPA class action brought on that. It was dismissed because that was a safety issue. It was an emergency issue. And then also school closing safety, another example. This hasn't been hugely litigated. It is relatively a narrow exception, but we do have some guidance now with some court decisions and then the recent FCC order. So calls to cell phones, if they're not made for emergency purposes and they're made using an ATDS or an artificial pre-recorded voice, have to be made with consent. And there's two ways you can get consent. And the level of consent that you need depends on the nature of the call. So if you are making telemarketing calls, if you're trying to advertise goods or services, you need prior express written consent from your customer, and you need an opt-out mechanism. And the party who, the calling party, the company needs to be able to demonstrate that there is that consent. Now, if it's a more transactional, purely informational, follow-up call type communication, you can have unwritten consent, or essentially consent that's inferred by the fact that the customer supplied the cell phone number to the company, and that is sufficient to satisfy prior express consent, again, if it's not a telemarketing call. And then the other issue that we see comes up with consent a lot is revocation. And so there are a lot of class actions that are based on revocation. So not that there wasn't originally consent. It's an admission. I did give my phone number when I opened this credit card account, but I revoked it when you started calling me. And so there are lots of class actions that come and that are just based on revocation of consent. And the FCC, the other way to avoid the cell phone ban, essentially part of the TCPA, is if the call falls within an FCC exemption. So as I said, the FCC has rulemaking authority, and it has exempted certain types of calls, and those are all specific types of calls that are found in various orders that the FCC has issued. But to give you an example of some of them, package delivery notifications, identity theft, data breach, prescription notifications, calls about hospital discharge orders, those are calls that have been exempted by the FCC so long as the called party is not being charged. Landline restrictions, slightly less onerous than cell phone restrictions, but they still apply. So there's a timing component to the TCPA that calls have to be made between 8 a.m. to 8 p.m. And you can use an automatic telephone dialing system like a predictive dialer, so long as you have a live agent, right, come on the line. But if you're using pre-recorded and artificial voice calls, those are also restricted. You do need consent if the call is made for a commercial purpose and contains an unsolicited advertisement. Otherwise, it's not required. So you can make political calls, you can make calls about school closings, prescription refills to landlines. And then as a best practice, you need, and for certain types of calls, including telemarketing calls, you need to identify yourself as the caller, and then you need to provide an opt-out mechanism. So before we turn it over to Robert for faxes, I know that many of you are here for the CLE today, and so let me give you the code. The CLE code is SS, as in Seyfarth Shaw, 8776. So that's SS 8776. And Robert, I'll turn it over to you to talk about faxes.
Thanks, Jordan. You'd be surprised that we're still talking about faxes here in 2020, but faxes are routinely used by lots of pharmaceutical companies, doctors' offices, and then also e-faxes are also within the ambit of the TCPA. And so the requirement under the TCPA is that you're not permitted to send unsolicited fax advertisements. And as the key in interpreting the TCPA is that you need to look at the definitions and see if the underlying statute, if the regulations, or the case law, defines, what is an advertisement, and then you could obviously see baked in to the prohibition is whether or not it's been unsolicited. So unsolicited means without prior express invitation or permission. And then the other hook for there to be liability is that it's actually an advertisement. And advertisement means under the statute, any material advertising the commercial availability or quality of any property, good, or services. And so there's been, some case law about, faxes that have been sent which were argued to be more for educational purposes as opposed to for an actual advertisement. And under the case law, advertisement's been broadly, construed to include faxes that offer free goods and services, like a desktop reference guide or free, dinner seminar. There's somewhat of circuit splits on the details when you're trying to determine whether or not this is a actual advertisement or more of an educational offering. And so, there's been some circuit split over time on that particular issue. The interesting thing about the fax component is that when you send one of these fax advertisements, you need to include an opt-out notice, and that goes back to the 2005 Junk Fax Prevention Act that lays out exactly what needs to be in the opt-out notice. And it's somewhat onerous as far as the information that's required there. It needs to be clear and conspicuous, placed on the first page of the advertisement. It must state that the recipient may opt out of future unsolicited advertisements. It needs to include a cost-free mechanism to send an opt-out request. And there's some other additional requirements too that are provided in the regulations. But that's one of the key gotcha aspects of the fax prohibition is that even if you originally had consent to send the fax, the FCC has indicated in their guidance that you need to include that opt-out notice even if you originally had consent to send the faxes, which was interesting and has created sort of a whole cottage industry on the gotcha aspect of, well, wait a second, all these people consented. I can show that all these people consented to receive faxes, but then the plaintiff's bar coming back and say, well, yeah, they originally consented, but you didn't include the opt-out notice, so there you go, that is a violation. And it gets to that level of detail, and there actually has been cases and settlements based upon that particular claim. I think as you can see under the TCPA, there's a lot of terms of art, and it comes up in all the different aspects, whether it's a text message, a telemarketer, whether it's a fax, And so it's really important to have a sort of a meeting of the minds as far as understanding what is exactly required before you engage in those communications. And the statute, provides for what our definition is here. So the best practice, the gold standard is this prior express written consent for telemarketing, and it must be signed and sufficient to show that the consumer received clear and conspicuous disclosure of the consequences of providing the requested consent. Namely that the consumer will receive future calls that deliver the pre-recorded message by or on behalf of a specific seller. Now, this is going to apply to text message as well. And having received this information, the consumer agrees unambiguously to receive such calls at a telephone number the consumer designates. So, this often is done. And then in addition, the written agreement must be obtained without requiring directly or indirectly that the agreement be executed as a condition of purchasing any good or service. And so you typically see that on many retailer sites when you click and agree to receive telemarketing communications, text messages from companies as a recitation of these requirements. And so it can be done electronically, and so this notion of sort of the written agreement where you have a signature, that's somewhat of a misnomer in the sense that you can do this all by way of text exchange, the opting in through text messages and the providing the disclaimers and sort of the check the box on the online platform. Now, one of the key things that Jordan brought up, and where you see a lot of cottage litigation as well, is about yes, I may have consented at one point to receive your text message or your telemarketing calls, but I revoked that consent, and then you kept on texting me or calling me. And that's significant because there can be often, technological challenges, people working off of old lists that may have been expired. And so, there's somewhat of there's a circuit split out there with respect to whether a consumer can unilaterally revoke their consent given as part of a bilateral contract. Some courts have answered that question no, and you can see on the screen those courts that have said no, and other courts have said yes, that there can be a unilateral revocation of consent. That becomes quite significant because if there's a good argument that the consumer revoked the consent, then there can be a liability for future communications, whether it's a text message or a telephone call or whatnot. The case law and the FCC has indicated that there's different ways that consent can be conveyed, or that the revocation of the consent can be made, whether it's a letter, an email, a statement on the phone. And the FCC has been pretty forgiving in allowing different methods of revoking consent. So whereas the provider or the company says, well, you can only consent this way, the FCC is sort of say that that's not necessarily going to be the only way that a consumer can revoke their consent. Another term of art, and it really only comes up in the fax context, because this law has grown and its tentacles grown and spread out over time, and it used to be that the established business relationship was sufficient and something that was useful, but really it only comes up now in the context of fax cases. And the established business relationship that's provided for provides to facsimiles, and it's been defined as a prior or existing relationship formed by a voluntary two-way communication between a person and an entity and a business with or without an exchange of consideration on the basis of an inquiry, application, purchase, or transaction by the business or residential subscriber regarding products or services offered by such person. which has not previously been terminated by either party. So that's an instances where there, you could have a business card, and say you are a solar sales person, and you've provided a business card, and you use that business card to send out a fax. And there's been cases where they said that could show that there's an established business relationship. But again, as I indicated, if you're going to send out faxes based upon an established business relationship, you have to include the opt-out notice. Otherwise, you could have a technical violation, even though you have an established business relationship. We've used another term of art, which is the opt-out. For calls to cell phones and landlines, the opt-out is typically automated. An interactive opt-out mechanism is required. That's the typical thing where you see stop as being a method to opt out of the receiving of the text message. For faxes, opt-out, as we indicated, is actually specified under the old junk fax law. It needs to be written, clear and conspicuous on the first page of the fax, and it needs to have specific language regarding that the recipient may opt out of receiving future faxes. The sender's failure to comply within a reasonable time is unlawful, and that you need to include a telephone number or fax number where a request can be sent. That used to be one of the tricks where you would provide the language, but you wouldn't let them know where where they could make that request to opt out, and so that's a specific requirement that they need to include a telephone number or fax number where the request to opt out can be sent. With that, I'm going to turn it over to Jordan. We've seen a lot of activity on another term of art recently dealing with the automated telephone dialing system.
So this may be the hottest term of art that's being litigated in the TCPA right now, and there is a deep circuit split in how to interpret what this means. So the TCPA and actually the Supreme Court just granted the petition for cert that was filed by Facebook in the Facebook versus Duguid case. And the Supreme Court will then be weighing in on this issue next term. And this will have a huge impact on TCPA litigation. So what is automated telephone dialing system? The TCPA says it's equipment which has the capacity to store or produce telephone numbers to be called using a random or sequential number generator. The court's opinions trying to parse the grammar of the statute are very dense and kind of hard to follow, but essentially it just comes down to this. Do you need to be using a system that generates random and sequential telephone numbers and can dial those numbers, or is it simply enough to have a system where you can upload a list of customers, for instance, customers that have given you their phone number, and then your system just dials those numbers? And so the Second and the Ninth Circuit have interpreted it broadly. So the ATDS means, if you upload a list like that, you're covered. The DC Third and Seventh Circuit have said no. The language about random or sequential telephone numbers that can be generated and dialed is a key part of the statute, and if your system doesn't do that, then you're not an ATDS. Right, so we'll see what the Supreme Court says next year when it addresses this issue in the Facebook case. I touched a little bit before on the recent ruling in the First Amendment case in Barr versus American Association of Political Consultants. A lot of companies and defense lawyers had hoped that this case would be a vehicle for basically invalidating the cell phone ban portion of the TCPA. It was not. The case involved a 2015 amendment to the TCPA that was added by Congress that essentially said phone calls made to collect a government debt are exempted, There were multiple challenges in different circuits. The Supreme Court, all those circuits basically agreed and said that exception makes an otherwise content neutral and First Amendment a statute that's not problematic under the First Amendment, it makes it problematic. So this exception, this carve-out for government debt exemption was the issue. And the Supreme Court basically followed suit. It said, we agree with the Fourth and the Ninth Circuits that this government debt exemption causes the problem, makes it a content-based restriction, and so we're going to level down. We're going to get rid of that restriction. Everyone is going to be on the same footing now. There's no exception for government calls. Now, this is odd because the remedy is antithetical to First Amendment law. So the political consultants actually proved a First Amendment violation, but they got nothing, and what the Supreme Court actually did is make a restriction on speech even broader. So it is a bit of an odd ruling, and that's why you see, if you have read the decision, a lot of the debate is on the First Amendment analysis point, and the TCPA and the abuse under the TCPA in terms of litigation and even political speech really get lost. And it's really kind of an academic discussion about First Amendment analysis. But the bottom line is that, this case is not going to invalidate the TCPA, and it's still alive and well. Our First Amendment challenge is dead, not necessarily because this case was only focused on the government debt exemption. It wasn't focused on the fact that the FCC has authority to make a bunch of exemptions, and that those exemptions can be problematic from a First Amendment context because they are content-based. Those types of challenges keep running into procedural hurdles that are kind of specific to certain court-made judicial doctrines like Chevron deference and the Hobbs Act. So there are lots of issues with why it's hard to make those FCC exemption challenges in a First Amendment context. In terms of the FCC orders, I'll just quickly touch on them again because I already, we're running short on time and I already did touch on them earlier. So person-to-person text messaging, if it involves human intervention, it's okay according to the FCC, even though you can send a great number, a great volume of text. But there was no specific ruling that platform was or was not an automatic telephone dialing system. Anthem, this is a healthcare petition that was filed where Anthem was seeking a broader exemption for healthcare providers. There already are some FCC exemptions for healthcare providers, and the FCC essentially declined to expand their prior exemptions. And then the COVID-19, so the clarification from the FCC that calls about COVID-19 are made for an emergency purpose and therefore not subject to the TCPA if they're from a hospital, healthcare provider, or local and state official, and they're solely informational and directly related to the imminent health or safety of the consumers. So what does the future hold? It holds clarity on what an automatic telephone dialing system is now that the petition for cert in Facebook was granted. There could be additional future First Amendment challenges based on FCC exemptions. There's also a debate on whether or not FCC decisions are binding on courts, and there is a lot of hostility, especially among the conservative justices, to the deference that courts give administrative agencies. So I think we're going to see, not just in the context of the TCPA, but in a lot of statutes where administrative agencies promulgate rules, a lot of action in the area, and that will affect TCPA and how courts interpret some of these terms of art that we've gone over. There's also, that aren't on this slide, issues about standing. Again, how many text messages or calls does it take to give you Article 3 standing, and then personal jurisdiction issues that are brewing. And there are also some related to faxes, so I'll turn that over to Robert.
Thanks, Jordan. Yeah, there was a significant fax case Recently, the Supreme Court declined to review a Ninth Circuit ruling regarding what does and doesn't qualify for an advertisement under the TCPA fax case. Fax cover pages were at issue. The defendant in the case allowed customers to send online faxes, and those faxes included a cover page with one line of text that identified the company and its websites. The plaintiff alleged that those fax cover sheets were advertisements, and therefore that the defendant had violated the TCPA because it didn't have the recipient's consent to send them. The Ninth Circuit disagreed and found that the language was at most an incidental advertisement that didn't convert the entire communication into an advertisement, considering the amount of space that was devoted to the advertising versus the amount of space used for the information. The plaintiff had found some cases in the Seventh Circuit that they believed went the other way and had filed a petition for writ of certiorari before the U.S. Supreme Court, and the court declined to review that. So there is a bit of a circuit split in the Ninth Circuit compared to the Seventh Circuit about what qualifies that as advertisement and what is incidental advertisement.
So to give you some best practices to take away on what to do to protect your company from exposure, we recommend keep your terms and conditions and privacy policies up to date. Look at those in particular for whether or not you have an arbitration clause and a class action waiver, because those are often the best vehicles to defeat TCPA litigation. And then consent. If you can, you should try to work to the best extent possible written consent into your terms and conditions and your privacy policies. Get it in writing even if you don't need it in writing, because it's just a nice, clean, crisp way to prove up that you have consent if there is an issue. And specify the method of how your customer can revoke their consent, or put in a provision that it cannot be unilaterally revoked, because you may get a court ruling that says, if you get hit with a revocation lawsuit, the court says the revocation wasn't valid because it didn't comply with what was in this bilateral contract. And then make the scope of your consent broad. Sometimes you may enter into a relationship with your customer that's, about a particular piece of your business, but over time it may change and expand. You want the scope of your consent to be able to reflect that. And we've got a few more best practices that Bart and Robert will give.
Yeah, thanks, Jordan. I know we're short on time. I think two things you should remember is, as Robert and I mentioned, service providers. We delegate a lot of responsibility for communicating with our customers and prospective customers through service providers. We need to make sure we vet those service providers, make sure they have the policies and procedures that match our own, and do some due diligence over what they're engaged in, because ultimately under vicarious liability and under the goodwill and reputation of your business, you're going to be liable. Even if you have an indemnification, that may only cover just some of the dollars and cents and not your goodwill and reputation. And then another, operationally, you probably just revised your privacy policy because of CCPA, or did it late last year, or maybe you did it because of the GDPR or another acronym. But while you're at it phase, really make sure that your opt-out under CCPA or GDPR mechanisms works its way to your mailing list. And I know in decentralized organizations that it's very, very difficult to control your marketing list and to understand what's happening on one side of the business versus another side of the business. But it's really important to make sure that you're not emailing someone who is opted out, and that you don't have an exception to email to. Robert?
Yeah, thanks, Bart.
No, I think those are all good tips. I think also we have on here complying with the do not call registry. Be mindful about who's on your marketing list. Make sure that those have been audited and vetted, and you know who you're sending to and whether they're good, and you have express written consent. I think with that, we fielded some questions during the webinar, and feel free to reach out to the three of us if you have any additional questions. We wanted to remind you of an upcoming webinar that we'll be having on July 22nd, part of our post-pandemic litigation series, the new era, new litigation lawsuits you can expect in the post-pandemic environment. You can also get access to some of our previous webinars on the firm's website. You're seeing a listing of those webinars on your screen now. And we also have a dedicated page about return to work and post-pandemic topics. So we'd invite you to check out those as well. And with that, we'd like to thank you for your time today, and have a great rest of your day. Thank you.
Thank you.
This concludes today's webinar. Thank you for attending.